All right, let's go ahead and kick things off. So thank you very much for joining us this morning. We appreciate your time and know it's very valuable. So this morning we're going to speak about the Secure Act 2.0. I'm Drew Barnes, Head of Financial Planning here with Traction Financial Partners, and I'm with Bob Haycoop, our President and CEO. And before we dive in, you are more than welcome to ask questions. We will be answering the questions that we can at the end of the presentation. So any questions, there is a chat box that you can go ahead and type those into. And of course, you can always feel free to follow up with us after the fact if you have any questions as well. So at the end of 2022, Congress, in their big $1.7 trillion omnibus spending bill, also passed what's called the Secure Act 2.0. The initial Secure Act was passed in 2019 and enacted and in force for 2020. And so they've made a lot of changes to enhance, in most cases, some of the laws that were put in place for that act, and some that are not quite as beneficial, but we'll take a peek at all of those as well. Interestingly, the initial Secure Act had about 12 provisions. This one has about 100, a little over 100. So this act is certainly broader and has a lot more changes in terms of overall scope. However, we would probably say that nothing quite as impactful as the initial Secure Act, which had the death, so to speak, of the stretch IRA. So if you inherited an IRA, prior to the initial Secure Act, you were allowed to stretch required minimum distributions out over your own life expectancy. They took that away and condensed it down to 10 years. So we don't feel there's anything quite as impactful in this Secure Act 2.0, but nonetheless, there are a lot of provisions in here that do certainly make an impact, presenting changes and a lot of opportunities to plan around that. So let's go ahead and dive in terms of an agenda. We'll start off with some of the changes made to the required minimum distribution ages. The initial Secure Act pushed it back from age 70 and a half to 72. The Secure Act 2.0 pushes that back further. There are changes to catch-up contributions for retirement accounts for folks that are still working and contributing to their 401k and other retirement plans. There are a bunch of Roth-related changes that we'll dive into, and then one of the kind of more interesting provisions in this act is the 529 to Roth transfers. So there's some interesting things there that we'll dive into, and then a handful of other notable changes that we'll wrap up with before we get to questions. So I think that probably the biggest change in the Secure 2.0 Act is just pushing back the required minimum distribution ages. So for anyone turning 73, this year through 2032, your new RMD age will bump up 1 year to 73 from currently being 72. And then anybody who turns 75 in 2023 and beyond, your RMD age will be 75. So this table just kind of summarizes it neatly for us. If you're born 51 through 59, your new RMD age is 73. If you're born 1960 or after, your new RMD age is 75. So that's a pretty big change from what it was just about 3 years ago when it was age 70 and a half. Regardless of age, it was 70. Now it's either going to be 73 or 75, depending on when you were born. So what does that mean for us? Well, first off, kind of just a fun fact is that there's no one who's going to have their first required minimum distribution this year, because if you turn 73 this year, you turned 72 last year and had to start last year. So no one's going to have their first RMD this year, but starting next year, 73-year-olds will. One of the laws that they made permanent a handful of years ago was the qualified charitable distribution, which is sending a charitable contribution directly from your IRA straight to charity. So it doesn't come to you, it's not counted as a taxable distribution. You don't also get a tax deduction for it, but it does not show up as taxable income. So in this day and age, when most folks are taking the standard deduction because they've increased it so much, and they don't have enough itemized deductions to be able to itemize deductions, a lot of folks aren't getting any kind of tax benefit for their charitable contributions. One way to get a slight benefit, at least, is with qualified charitable distributions, or QCDs. What they did not do, it used to be tied to being in required minimum distributions. They left it at age 70.5 in the initial Secure Act, and same with the Secure 2.0 Act. So if you're age 70.5, but yet haven't quite yet started your RMDs, but let's say you give a couple thousand a year to charity, but you don't itemize deductions, it probably makes sense to give that straight from the IRA as a tax-free distribution, which will also, lower your ultimate required minimum distributions, because that calculation is based off of the amount in your IRA. And not that it's a big deal, you can do up to 100,000 a year. Not many folks are doing that because that's a really high amount. But beginning next year, that 100,000 will index for inflation. And it does provide us planning opportunities. So we kind of call it the sweet spot for tax planning, because a lot of folks have retired from work, so they're no longer in their high income earning years. Whether they've started Social Security or not, that's typically much less than they were earning when they were working, but they haven't started requiring minimum distributions yet. So we have this gap of time where tax rates are very, very low. And it's nice to pay little to no taxes. However, we kind of want to find an equilibrium if we can. It's not great to pay little to no taxes for a few years, but then really big taxes on the back end once required minimum distributions kick in, when you have no choice and you have to take those distributions and they're fully taxable. So what we do with a lot of clients from a planning perspective is we accelerate the income coming out of IRAs for those years prior to RMDs. So whether that means Roth conversions, which is taking money out of your IRA, converting it to a Roth, it is taxable to do so. But if you can convert at a lower rate, while your tax rate's low, you're normally saving taxes over time. You can continue to make those QCDs to charity for a longer period of time, further lowering the account balance and lowering the ultimate RMDs that you'll be required to take out. Or if, of course, most people are needing to live off of their IRAs once they're 70 to 75 or 73 and haven't started RMDs yet. So you can just take your normal distributions at that lower tax rate. So it just gives us a longer window to be able to hopefully lower lifetime taxes for people. And with that, there are some RMD options for surviving spouses that are pretty appealing. So normally when you pass and your spouse inherits your IRA, normally you just roll it into your own IRA, which you certainly can still do. But now this law allows us to be able to treat the inherited IRA as if you were still the original IRA owner. So I have a couple of examples here. So Betty's 67 and Tom is 71. If Tom passes, Betty still probably wants to roll Tom's IRA into her own IRA, because Tom at 71 was just 2 years away from required minimum distributions, where Betty at 67 is 6 years away. So she can move it to her own IRA, delaying RMDs for an additional 6 years rather than just 2 years. However, if the roles were reversed and it's Betty who passes, Tom can now elect to be treated as Betty in terms of her IRA that he inherits. And the reason he would want to do that is because, again, instead of rolling it into his IRA, starting RMDs in 2 years, which now his IRA balance is bigger, they calculate RMDs with the year-end ending value of your IRA divided by a life expectancy factor. So the higher the amount in the IRA, the higher the amount the required minimum distribution. So he can now elect to treat it as if he were still Betty, delaying the RMDs for 6 years rather than the 2 years till he reaches RMD age. And also the RMDs are going to be lower because it's going to be, the IRAs will be separate, so it won't be combining the balances there. So that's a pretty nice change to the law that'll benefit retired couples in terms of inheriting their spouse's IRAs. And with that, that's the bulk of the changes that we wanted to be sure to cover from an RMD perspective. So again, I think that's probably the biggest impact is everybody who's not already taking RMDs will now be taking RMDs at a later age. And it gives us some additional planning opportunities. And with that, there's a lot of changes to catch-up contributions, and I'll turn it over to Bob to tell us about those.
One thing that's consistent is Congress will keep all of us guessing on some of the things that are available to us, both benefits and things that might be challenges. So we continue to want to provide you information. So when we talk about catch-up contributions, as it stands right now, those catch-up contributions, you're eligible to do that with an IRA, whether it's a traditional or Roth, or if it's a employer-sponsored plan, such as a 401k, 403b, or the governmental 457 plans. But they've made a change that impacts what you benefit from, because the employers, if you're a high wage earner, and that's currently defined as anybody in the previous calendar year that has earned 145,000 in wages or more, that catch-up has to be made from the employer into the Roth option. So that is a significant change on the catch-up contributions, and it's important to note that if you are someone who qualifies as a high wage earner, whether you're making Roth contributions or not from your own wages, your employer has to make those into a Roth account on your behalf. So an example that we have here, say your wages were $200,000, but you had only worked for the company in the previous year for 6 months, meaning you only earned 100,000 of that. The way we understand Secure Act 2.0 and those provisions is you can still make your traditional, or the employer can make their traditional match into the pre-tax contributions. But once that exceeds 145,000, then we certainly need to make sure those are being accounted for and contributed correctly. One thing to note there is as you do planning, as you know, you think about inflation, which is on everybody's mind today. We don't know, and we couldn't find any guidance on whether that 145,000 will inflate with cost of living or not at this point. So stay tuned on that. One other thing to keep in mind, if you are an employer or an employee, this only applies to those folks that have W-2 wages. So if you're self-employed, such as a sole proprietor or a partnership, you'll continue to have the same opportunities on the catch-up side without having to use the Roth option, even if you are a high wage earner. Starting in 2025, the retirement plan catch-up contribution limits from age 50 until you hit 60 will be the same, but then they've made a provision, and we're not quite sure how they came up with this formula. Sometimes we all are left scratching our heads at legislation that comes out. But when you're 60, 61, 62, or 63, your catch-up contribution can be either the greater of $10,000 or 150% of what the regular catch-up contribution amount is, which is indexed for inflation. So currently in the year 2023, which this doesn't apply to yet, it's $7,500. But if you took 150% of that, that would be over 11,000, which would be the greater of 10,000 or 150%. So keep that in mind. It allows those of us that are in our early 60s that want to put even more away out of our paychecks in the catch-up contribution category to accelerate that just a bit. If you have a simple plan and you're participating age 60 to 63 will also have their limit increased, but it's a little bit different on the simple plans. It's either $5,000 or 150% of what's the regular simple catch-up contribution, which would put it at $5,250 if you use the 150%. Okay. Some other interesting things, and as Drew mentioned in his introduction, many of these changes are Roth related. And just as a reminder, Roth is after-tax money that is not taxed as it accumulates and grows or when it's distributed. So no required minimum distributions for Roth accounts in employer plans beginning in 2024. Currently, you may or may not know, but currently Roth IRAs are not subject to required minimum distributions. But if you have a Roth option in your sponsored employer plan, those are subject to RMDs. The other thing that's interesting is you can create a simple or SEP Roth IRA beginning this year. And that would really be important to do some planning work, whether you're an employer, self-employed, or whatever it might be, to take a look at that and see if that makes more sense than the traditional pre-tax simple or SEP. Another thing to consider, there are some additional employer contributions for Roth treatment. So employers that with their plan are currently permitted to make matching or non-elective contributions to an employee's designated Roth account. So that's something there that can be a significant benefit, that they are permitted to do that. We don't know if the employer makes that decision or the employee. Based on what we can understand, we believe it's the employer's decision if it's their match. But if they do match, that's included in income because Roths are taxable before they go into that retirement account. Next, we'll chat about another unique opportunity that I think makes sense for many people that have funded a 529, whether that be for your children, your grandchildren, nieces or nephews, or other people that you've taken a special interest in to help them fund their higher education. As it's noted on there, some individuals can transfer 529 plan money directly into a Roth IRA, and we'll cover here the conditions that are met. 529s are after-tax contributions. They're treated from a tax code standpoint the same way that we see Roths, where the money goes in after tax, so it's after tax earnings. It grows tax-free and it comes out if it is used for higher education expenses that qualify. To transfer, so many times what happens is when you start a 529, whether it's for one of your children or someone else, when that happens, it's many, many years before they start college generally. And you don't know what they're going to do. You don't know if they're going to go to a trade school. You don't know if they're going to go to a local community college, to a state university, or they get a full ride scholarship to a private university, such as Baylor, or they go to Harvard. And since we don't know that about our kids and what ends up happening later in life and in high school, many times we accumulate a significant amount of money in there. But if you're really bright, like Drew, what happens is you get all these scholarships and you don't need all that money. There isn't the same cost and you end up having a balance once you've graduated. So the first item that that's a condition that needs to be met is it must be transferred to the same beneficiary. So we'll use Drew as an example. So if Drew was the 529 beneficiary, he also has to be the Roth IRA beneficiary. The plan must have been in place and maintained for at least 15 years. So that really applies when you've started one, when kids are young, before they start kindergarten. Typically that plan's been in place for 15 years and through their college years, whether they're someone like Drew that goes to college for 4 years or me that took 7 years to get through college. Contributions also that are made in the previous 5 years are not eligible to move to a Roth IRA. The annual limit amount that can be transferred is something to consider as well. They do not allow you to put any more than what the normal IRA contributions are, which in 2023 is $6,500. So for example, if you had a $50,000 balance, the most you could transfer if the other conditions are met would be $6,500. And you do have to wait at least 5 years since the last contribution. The other thing that they put a limit on is the maximum you can do in the lifetime, which is $35,000. And Drew and I discussed this a bit and scratched our heads and wondered how they came up with this number, because it does appear that many things that Congress comes up with, there's some randomness to it, or there's obviously been some negotiation in committee. But we suspect that that may be what the average balance is when someone graduates from college, and that's why they limited that. Because if they limit it, that also means that there are some restrictions and there's some tax dollars that they anticipate coming in the future. So the most you can contribute at that $6,500 a year or transfer would be maxed out at $35,000. A question that we had, and maybe many of you do, we don't know if that ever gets indexed for inflation, but there again, most legislation, they provide some guidance and clarification in the years coming, because there's a number of, I didn't think about that, things that show up. Drew?
All right, thank you very much, Bob. And I suppose one thing I'll add to that is there's nothing that we saw in the law or in our research that indicates that you could not make yourself the beneficiary of the 529 and then transfer it to your own Roth. You can freely change the beneficiary of your 529 plans as long as they're a related family member. So oftentimes you could just change the beneficiary to yourself, or if you, in the examples that Bob gave, where one kid maybe gets a bunch of scholarships, so there's a lot of money left over in their 529. Then you change the beneficiary to one of your other kids who's not going to get that scholarship, so you can use the monies there. So we don't know, there's nothing in the law that we see that says you can't make the beneficiary yourself and then contribute to or transfer it to the Roth. However, of course, the rules still apply. You do need earned income to be able to contribute to a Roth. So you can't do it if you're retired or anything like that. However, if you did do that, we don't know if that then triggers a whole new 15-year period. So there's, as Bob mentioned, there's a lot of things that need to be clarified, and with time, hopefully we'll get some of those answers. But as of right now, that's the information we have. And as I mentioned in the introduction to our discussion today, this Secure 2.0 Act has over 100 different provisions in it. So there's a lot of things that we are not going to cover today that are in there. So a few other notable changes that we thought were certainly worth mentioning, and again, this does not cover everything, is that starting in 2023, sole proprietors or businesses that are taxed as such can establish and fund a solo 401k for a previous year up to the tax filing. So if you're an LLC and you're taxed as a sole proprietor, let's say you have a SEP IRA, you're always able to open and fund a SEP IRA up until April 15th for the prior business year. They never allowed that for solo 401ks, which, depending on the circumstances, can allow someone to defer more money and save more into a solo 401k. We actually had a client just last year. We were trying to open a solo 401k under the gun by the end of 2022, and we didn't quite get everything in place, so therefore we couldn't make those contributions. So we're doing one more year of SEP contributions, and starting this year, we'll then do solo 401k. So it's very similar to a SEP IRA, where now you'll be able to make those contributions or even establish the entire plan after the work year and prior to tax filing. So that's a provision that we like. If you don't take your RMD, or if you don't take the full RMD amount, you're penalized 50% on whatever that shortfall was. So if you had to take out $50,000 and you only took out $10,000, the remaining $40,000 they would put a 50% penalty on, which is very hefty. So you'd have a $20,000 tax bill for that. In this, they're lowering that penalty to 25%, and even lower to 10% if you're able to correct it within what they call the correction window. Basically, if you catch it, early in the year following the prior RMD year, basically before the IRS reaches out to you, they'll lower that to 10%. Now, you still are able to file for an exemption altogether if there were some circumstances that are understandable. They can waive it altogether, but if you just forgot to, or whatever the case may be, they do lower that penalty for you. Starting in 2024, next year, employers are allowed to do matching contributions for payments that their employees have for student debt. So, oftentimes these days, folks are strapped with a lot of student debt. Therefore, they can't contribute as much to their retirement plans as they're paying down that debt. Well, if you make student debt payments, now your employer can make matching contributions into your 401k equal, and there is a limit, of course, but equal to that, to where it kind of makes you whole on the retirement savings side. Also, starting next year, simple IRA plans, you can make additional non-elective contributions for the lesser of 10% of the compensation for the employee, or 5%. Currently, you're limited, depending on how you have a simple IRA set up, to either a 3% match or a 2% non-elective contribution, regardless of whether or not the employee is putting money in. So you can increase that amount. And a lot of small businesses have simple IRAs because they're a little easier and certainly less costly from an administrative perspective. But simple IRAs have lower contribution limits, both for the employee and the employer. So they're trying to enhance that a little bit to where folks who have simple IRA plans are able to save a little more, or the employer can. Also, starting next year for simple IRAs, there are contribution limits that will increase for certain businesses depending on the company size. So if you happen to have a simple IRA, that's something we may want to look into. And then starting in 2025, for new 401k plans and 403b plans, there is automatic enrollment, where the company will have to automatically enroll all employees into the plan and contribute 3%. That they'll require the employee to contribute 3% with automatic annual increases of 1% up until 10% or so of compensation for the employee. The employee always has the opportunity to opt out of that, but it's just a way to get people on a track to saving for retirement. There are exclusions to that if you've been in business for less than 3 years, if it's a church plan, a government plan, simple plans, or if you have less than 10 employees for the business. So those are just a handful of other things that we felt were certainly impactful, depending on, of course, the individual situation. And so with that wraps up the changes that we wanted to be sure to discuss today. Of course, there's going to be more information coming out. There's going to be a lot of clarifications. And as time goes on, people always find a way to take advantage of any loopholes that may be written into the law. So certain things obviously may change, and we'll always keep a close eye on that, so we're able to best advise you depending on your situation. So with that, we will turn it over to questions. We'll give it a few minutes to see if anybody has questions that come into the chat box. So please do feel free to type any questions in there. And as always, feel free to follow up after the fact with anything that you may want to discuss as well. And with that, we'll go ahead and see if there's any questions coming into the chat box. As of right now, I don't see any, so we'll give folks a minute or two, but otherwise, thank you so much for your time this morning and listening into the Secure Act 2.0 presentation. We really appreciate it. All right, so far no questions are coming into the chat box, so we'll give it another minute or so, and then otherwise we'll wrap up and let everybody get to their Tuesdays. Thank you very much, Katie. As a reminder, this presentation was recorded. We will be sending it out via email and also eventually getting it added to our website. So please do feel free to share this once that comes out with anybody you think may see any value in the information. And with that, I haven't seen any questions come in, so thank you so much. And we will look forward to seeing and speaking with you all soon. Thank you.
Thank you, everyone.